Okay, very good morning. Assalamualaikum. Topic today is on business law to all East-West International College student and also UITM student. So the topic today is acceptance. So learning objective is to understand terms of acceptance, define intention to create legal relation, and explain consideration. So what is acceptance? In order to have a valid contract, this important word, you underline it, valid contract, valid contract in your notes. So we will repeat all the time in the lecture, valid contract, valid contract. So in order to have a valid contract, there must be both offer and an acceptance of the offer. So you can see here, offer plus acceptance is equal to contract. There's no offer, no acceptance, or either one is not there, there's no contract. Very simple, very basic thing. But after all, we can see things get complicated. What is offer, what is acceptance, what is contract. Okay, but basic thing, valid contract mean you must offer, you must have acceptance. Okay, what is acceptance? Just now we said offer plus acceptance. Okay, we see what is acceptance meaning. If the method by which acceptance is to be signified is indicated by the offerer, that method alone will be effective. If it is not, acceptance may be either expressed by word of mouth or in writing, or inferred by the offeree's conduct. Example, if you receive goods and make use of them, must involve some action on part of the offeree. Okay, this is very legal wording. So for you student, you definitely cannot understand this one. You don't take up law subject, it's very difficult to understand. Let me try to simplify and for you to easy to understand. But again, this law subject is the, remind you, not the easy subject lah. So just try to bear with it lah, to understand slowly lah. Yeah. But you need to know basic thing only lah, not too deep. So let's say this number, if the method which acceptance to be signified is indicated by the offerer. Offerer that means the person who going to sell it lah. So you might understand offerer. Those who want to sell, we call it offerer. Yeah. Then if it is not acceptance, maybe either expressed by word. So first part tadi yang offerer tu, how they want to offer you, it can be many ways. But also by can word of mouth or in writing. Let's say today lah, very simple lah. I give you a good, very simple example, easy way to understand. Let's say you want to sell the old book to your friend. Your friend don't have a book. You're from senior student, but the junior student need a book. So you can say that I sell this book to you, this is my old book to you at 30 ringgit. That can be offer already. Yeah. So that means we just offer it by word of mouth only. So contract. And if the party, your friend say, yes, I accept your book at the price of 30 ringgit, he already accepted. Also by mouth. So in that situation, contract done. It's a valid contract. Later on, you must understand what is valid contract. When we talk about valid contract, so if you sell, the other fellow accept. If you don't give your book, they can take legal action at you. Although this is small amount lah, but what I'm trying to say is a valid contract. It can be legally executed if you refuse to give the book. I mean, he can go to court and ask court instruct you to give him the book because you already agreed to sell. If you don't, then the court may jail you or fine you, whatever lah. What I'm trying to say, there's a valid contract. When it's a valid contract, you can refer to the court in case any party fail to deliver their promises. Okay. Also in writing, but as you know, most of the contract are in writing lah. So I'm just talking to let you know here, the contract which is mostly in writing, but also can be used word of mouth. Yeah. So must involve some action on the part of the offeree. So the offeree, the person who want to sell it, must do the action lah. If he's quiet only with the book, he didn't say you anything, he's not selling anything to you, right? So simple as that lah. Just understand the basic understanding of the acceptance. So validity of acceptance. How long the validity of acceptance? It must take place while the offer is still in force. Let's say now, just now, very simple. You said you want to sell the book to your friend, 30 ringgit, and you must accept it by today. If he didn't accept it by today, he accept it by tomorrow, the offer does not valid anymore. Simple as that. That means the offer does not still in force. No more in force lah. Yeah? It must be on the same terms on the offer. Okay, what you mean here? You mean here, if you said, I want to sell you the book at 30 ringgit, the fellow who accept it, so no, I want it to buy it from you at 25 ringgit. That is counter offer already. So there's no validity of contract there. Okay. It must be unconditional. The contract so must be unconditional. Just now you said you counter offer a different price, but here the person who want to accept your offer, the book, he will say, I want the book, but you must cover it with proper plastic folder or something like that. Your friend want to buy from you, but he give you some condition. So the acceptance is not valid. Yeah? You must say, okay, I accept the book as what you are selling to me. Then that means no condition lah. Then only the validity accepted. It must be communicated to the offerer. So that means you accept, you must tell back the offerer. If you in front of her, it's okay, in front of your friend. But if you at the home, you are a different place. So if he said that, he called you, telephone, and said, I offer you this book at 30 ringgit. Then you say, okay, I will think it over. So, but he said by evening, you must let me know, right? So by the evening, you must call back, communicate back to her, yes, I accept your book at 30 ringgit. That's what you mean, okay? This is a very simple thing to understand, but if you read there, very difficult to understand what it means. Yeah? I give you the simple explanation. That's good enough for you to understand validity of acceptance. Yeah? Whether it's valid or not, the contract. Counter offer, okay, I already told you just now. If you give another condition, everything, we call it counter offer lah. Simple as that lah. Yeah? That means counter offer. Special case, when the offer consists of promise to confer a benefit or whoever may perform in special act, the offerer waives the requirement of communication. This one, special case. So for special cases, example, let's say now you ask somebody to give you some information. Yeah? So you don't have to pay, the other party does not have to pay you any consideration. So when you give the information that you want to, you ask them to do, that means once they give information, you have to, the contract is fulfilled. So this is a simple special case lah. Yeah? Not to worry lah, this is not much of an important thing. So we have the example there, the special case. That means if the offerer offers a reward of information, a person able to supply the information is not expected to accept the offer formally. So the act of giving information constitutes the acceptance. Okay, the combination of acceptance and the performance of the contract. So that means the contract complete already. Okay. Breaking, now breaking contractual negotiation. So in legal term, where the doctrine of good faith is recognized, breaking of contractual negotiation may give rise to legal consequence. No duty to negotiate in good faith in law. No liability for pulling out of negotiation at any stage of whatever. So, I give you the example just now. If you want to sell the book, okay lah, we give it better lah. We want to sell a motorcycle to your friend at 1,000 ringgit. Your friend accepted already, agreed to pay 1,000 ringgit. You just by word of mouth, so the contract is valid. So if you break the contract, that means you tak jadi, you didn't sell, you don't want to continue to sell the motorbike to your friend. That means you are breaking the contract. So if you break the contract, your friend can go to the court to take legal action on you. Either they will ask the court to give order for you to sell the motorcycle to you, or they ask for compensation. So very important. Once you have a contract, you break the contract, there may be legal repercussion on you. Okay. Sufficiency of acceptance. The acceptance official must satisfy certain basic requirements. An acceptance must present some proof that the person accepting the offer has manifested agreement to terms of offer. So acceptance must satisfy certain basic requirements. So when there is no clear evidence that the person gave verbal acceptance, the acceptance can be inferred from his action. The person must show some objective action that clearly signal his intent. So some sort, now you want to sell a motorcycle to your friend. He said you want to sell at $1,000 the motorcycle. He didn't reply anything, but he nodded his head. You know what I mean? Nodding his head. So it shows that he accepted your offer. So that also can be accepted in contract, because by word of mouth, by verbal, or by writing. So by nodding is by verbal. So contract already can be done. So sometimes we thought that you just offer, simply offer, there's no contract. So be careful. You don't think that contract is only in writing. Don't simply joke around, oh, I sell my motorcycle at you at 50 ringgit. And your friend not. That means the contract done. And you think, no, I just joking only to pay 50 ringgit. No. It's already done. So this is why it's important for you to learn this contract subject, so you don't get into mistake in your life, daily life. So this subject is also about law, but actually is for your own use. That's why this subject is important that we have to teach you. Communicating acceptance. For a person to accept the offer, he must do more than simply state his wishes and enter into a contract. So when offer fails to state a particular mode or method of communicating acceptance, any mode will be sufficient. Just now I said communicating. If you want to communicate to your friend to buy a motorcycle, your friend is not in front of you, but is at home or somewhere else. So there must be communication, either by telephone or by writing or anything. And they must accept whatever the communication back. If by telephone, he has to telephone you back. If you send him a note or WhatsApp or something like that, he has to WhatsApp you back, saying that yes, he accepted your motorbike at 1,000 ringgit. So this is what you get communicating and accepted. So you must communicate to, and they also must communicate back to you. So to valid the contract as the acceptance has been completed. What words are required to indicate acceptance? So what word? Do you say I accept? It's not required. The person accepting the offer must communicate. So how do you communicate? That the person who made offer understand that he is accepted. Acceptance must be unambiguous. That means very clear cut. Yeah. So whatever the party who want to accept your offer, they must some situation that he must show that he accepting by way of nodding or by way writing back to say they accept, or communicate you by WhatsApp say that he accepted. That must be something that shows that he already accepted. Otherwise, the contract is not valid. Yeah. Again, we're talking about valid contract. If the acceptance is not by the proper way, even he accepted it, it can be invalid. Okay. Acceptance without words. A person can even accept a contract without saying nothing. As I said just now, if you nod your head in front of your friend, it can say that you accepted already. In this case, actions speak louder than words. Okay. So even you don't speak, but you give a nod, it's already accepted. So when the offer calls for bilateral contract, example, a promise in exchange for promise, silence is usually not permissible in method of acceptance. So I give good example last class. Say that there are those days in India when the boy and girl want to marry, um, the parent of the boy will go to the girl house and ask the parent of the girl whether his daughter would like to marry with his son. So sometimes the mother will call the daughter in front of this boy parent and ask, he said, this boy parent come here and want to get his son married to you. So in this case law, his daughter silent, keep quiet, keep quiet. So but the mother thought when she keep quiet, maybe she's shy or whatever, she proceed with the marriage. And the girl went to marry, maybe afraid of the parent. So one day he went to the court after married, he said that he didn't agree to the marriage. There's no contract. Because he said he was silent. He didn't put a note, he didn't say yes, he didn't say accept, or he didn't say any word. And the court case held that the contract is invalid. So the marriage was invalid, have to break up. So this is important. Silent, if you in silent, that means cannot use it as an accepted. It must be in word or in nodding or something physical to show that you're accepted. Just in this situation, we have to tell you, if you're silent, if your friend, you want to sell your motorcycle to your friend, if your friend silent only, that means he's not accepted. This is the example that you want to let you know. Power acceptance. The power acceptance is in term used by the court to describe the rights of party to accept an offer and thereby create a binding contract. The power acceptance can shift from one person to another during course of negotiation. So who has the power to acceptance? Sometimes we see in contract, in writing contract. Person want to sell one house and buy, the other person want to buy another house, ready house lah. They don't meet each other. They give the power to the lawyers. So the lawyer, if you give the power to sell your house to the lawyer, so the lawyer can offer. And the other party want to buy, he gives the acceptance to his lawyer. His lawyer also had the power to accept. This is simple as that lah. We talking about power acceptance. Either you personally or can other people to accept or not? Yes, can, if you give them the power. Or normally we call it in law, we can give them power of attorney lah. Condition and limit. Offer can contain manner of condition regarding acceptance. So, as I said, condition, it must be clear cut. If the condition not clear cut, and then the contract is not valid. What you mean clear cut? Let's say you want to buy a horse. You must be very clear, is it? I want to buy a horse with a white color. Because if you buy a horse, then somebody else come back, they give you a green color, they say, no, I don't want this horse. Actually, I want a white color. But the condition just now, you don't put in the condition as white color, then again, there be problem in the contract. So condition must be clear cut. Restriction to communication acceptance. When an offer does not provide any limitation on the manner and mode of communicating acceptance, it can be accepted in any manner. Well, if you say that, okay, I just want to buy a bicycle. You want to buy a bicycle. So the shop will just sell you a bicycle. There is acceptance is there. Because why? You don't put any condition. I want a bicycle with red color. I want a bicycle with a lamp. I want a bicycle with get this gadget, that gadget. So if you don't put a condition, you just say you want to buy a bicycle, that's understood. There's a normal bicycle that as you can ride. There's maybe a light there already, then can be, the contract can be valid already. Otherwise, it's very difficult. Everything you want to buy, you want to put condition. You go to the supermarket, you want to buy something on the shelf with all the condition. And then you take hours and hours to sign a contract. To certain product, is understood. We call it, can be used already lah. The product can be used, so there's no need to put condition. You buy in the supermarket, let's say powder milk for your mother. Do you need to put a condition, this powder milk must have this vitamin, that vitamin, this all kind of thing? There's no need, right? So that is understood. This product you buy is already have those that you need. Otherwise you don't buy it. You know already this condition is already there. What is inside the powder milk have? Limit acceptance. When offer does not contain any language expressly limiting time which offer said the offer will remain open at reasonable period of time. So this is always a problem when you to go to court reasonable period of time. Yeah. Let's say now you offer to your friend to buy your motorcycle. You didn't say that you must accept it by this evening. So how? When is the last time that your friends will have to come back to you to say whether he want to buy or not, you want to accept or not? So some people just like that. Okay, I want to sell you my motorcycle. I want to sell you my car lah. He just said like that. But offer, there is an offer already. There is a valid offer already. So you want to sell a friend to the car, but didn't give any time limit. So what do you think? Do you think the friend can wait another 1 year to come back to you? Here in law, they said reasonable time. Problem reasonable time is does not really stipulate. So normally, if this kind of situation, we talk about 2 weeks time lah. That means if you offer them and say I want to sell my car, so your friend there at least must come back within 2 weeks time to see whether he accept or not. If more than that, cannot be after 1 year they come back and say I want to buy the car. So if they go to the court, they say that look, my friend offer this, after 1 year I want to accept. The court said no. Must be a reasonable time lah. Although he didn't say your friend offered you, does not state the time, period of time. But reasonable lah, if 2 weeks or maybe 1 month, reasonable. But now you come after 1 month and want to endorse the contract, enforce the contract, the court may say no lah. Yeah. But again, I said it depends on the judge lah. Yeah. But we're talking reasonable time, 2 weeks, 1 month, reasonable lah. That's why when you offer, it's better you specific the time limit. But some people, they don't. So this also happening. Is a problem. So waiving a stipulation condition, the person making offer is always free to amend his offer or to waive the special condition. Okay, let's say I want to offer you to buy my motorcycle. Yeah? But if you buy my motorcycle, I give you one extra battery for the motorcycle. Then he didn't accept the thing. He said, I give you 2 days to accept. So the next day, your friend have not accept. You can waive your condition. You see, now since you don't accept, I will sell my motorcycle with you. I'm not going to give you the battery. Can. Before the party accept your offer, you can waive whatever condition. Okay? But we make it simple and clear. Acceptance must be clear cut lah. Unambiguous, but the meaning is clear cut. Yeah? So again, what you say, when you accept, you want to sell. When you accept, you must accept what they offer. You cannot give another condition or kind of thing. It become not clear cut, and then your acceptance is not valid. That's what we're trying to say here. Simple as that. Yeah. You cannot say word perhaps. Okay, maybe I buy a motorcycle. Perhaps you give me extra. You give me new tire or so kind of thing. That is no more acceptance. There's some sort like you're asking for new condition or some kind of thing. That means it's not clear cut, and then your acceptance is not valid. Simple as that. Okay, accepting alternative terms. An offer can include alternative terms. Yeah, an offer can also contain indefinite quantity. So okay, you can give alternative terms. You said I will give you sell your motorcycle, but I give you alternatively. If you don't like this motorcycle, I'll give you another. You don't like this you got 2 motorcycles maybe, or two cars lah. I sell you this red Proton. But if you don't like this Proton, you can take my blue Proton car. It's an alternative term, so you can put down there. Both are Proton car, but because of color, maybe they don't like, you can offer them. You have 2 cars. Which one you can take? An offer can also contain an indefinite quantity. Can also contain, let's say, somebody want to come to your village to buy durian from your durian trees. How you want to calculate how many durian you have in the trees there? Yeah. So you can sell. This happening. Okay, I said I sell this durian trees fruit when it start fruiting. Do you know how many fruits the durian tree is going to fruit? You don't know, right? So can. You can say, I sell this durian fruits from this durian trees when it's fruiting, but I don't know the quantity. Whatever, like next time the fruit, you take it. Can. You can put that as condition. Because you cannot calculate the quantity. Yeah? Interesting, eh? Sometimes you don't see it happening. It's happening. Especially when you go to the village, they want to buy a durian fruit, they want to buy a rambutan fruits from the tree. How are you going to calculate? How many rambutan are there in the trees? Okay, you say, okay, you can buy this rambutan trees, I sell you 100 ringgit. Quantity, whatever down there. Lah. So, no specific, right? But can also, because it's impossible for you to calculate the number of rambutan inside the tree there. Correct or not? You think a little bit, it's a logic lah. Yeah. Otherwise, you can, if there's contract, cannot be that way, then cannot sell buy the durian trees lah, the durian fruits lah. Cannot buy sell the rambutan fruits lah. Correct or not? So, in contract, there is possible, depend on the situation. Setting by mail, unless otherwise stated, the offeree is usually free to accept offer by posting email. Okay, this is a general rule lah. General rule from those days, they use mail. Mail. That time no fax, no telex, no WhatsApp, everything. So in general rule, you write a letter to your friend. If you didn't meet him, your friend is in Kuala Lumpur, we're here, you mail him or now email him saying that I'm offering you this. And he can accept by mail also. Done, contract done. Okay, this mailbox rules is old rule lah. This not now. If you explain to you, I'm going to explain to you quite long, but nowadays people don't use this mailbox rule. Just for your info lah. Yeah. But I believe you don't have to pay attention because this is old days mailbox rule. What we just mentioned here lah. But for me, no important for the current situation. Exception mailbox rule, same thing lah. For me, this mailbox rule is obsolete already. But we just mention here because it's part and parcel of the subject that you must learn lah. But in reality, it's no use, no point explaining down you here because we don't use mailbox in daily transaction anymore. Okay, rejecting an offer. When offer has been revoked, cancelled, there is no power of acceptance and therefore there is no way that person can accept. Simple. I offer you to buy my car, you must accept by tomorrow evening. So that tomorrow evening, your friend does not accept it, that means your offer has been revoked. So one revoked, contract cannot be done, cannot be accepted. Simple as that. So an offeree may reject an offer through action instead of word. Okay, you can put in action or word. Let's say suddenly your friend appear the third day in your house. You're supposed to confirm to buy the car the next day. The third day he came to you. Then said sorry, you just can shake your head. I already told you must accept yesterday. Today is the third day already. So the contract is off. You don't need to say anything. Also can. Once an offer has been accepted, the offer cannot be revoked. But once accepted, as I said just now, it becomes a valid contract. When it becomes valid contract, you don't perform the contract, they will bring you to court and you subject to court action. Yeah? Okay, modifying of terms of acceptance, I already told just now. Okay, acceptance by agent. Okay, you want to sell a car. Now, let's say you want to sell a car. You sell a car, you give it to the used car to sell for you. That we call it, you give it to an agent to sell from you, and you can buy the car through the acceptance. So the seller, the offeree, and the buyer don't know each other because it's done through agent. Simple as that lah. Yeah? Intention to get litigation. Okay, it can be shown that it was not intention of parties to create legal binding relationship. There is no contract. You want to offer, the other want to accept, but there's no intention for both parties to do it. So there's no contract. You must have the intention. What mean I say I intend to sell the car to B. That means my intention is to sell the car to B. But suddenly now, C come and accept to buy my car. So there's no intention. I have no intention to sell to C. So if that the case, although you want to sell a car, but the acceptance is through C, so but you don't have the intention to sell to C for what reason? You don't like his space kind of thing. So because of no intention to create liquidation to the person you want to sell, so the contract cannot be valid, even the offeree come to buy from. Unless say, okay, I agreed to sell to C also, and then can be done. But if not, no lah, because you have no intention to sell to C. That's what it means. So contract is quite specific. Yeah? But sometime in the world you don't have the kind of situation lah. You want to sell a car to B, suddenly B does not respond after next day. Then somebody comes C want to sell. Then you want to sell to C. So your intention to sell to C, it can be done lah, no issue. Yeah? But in law, this is a point that we raise up to you lah. Yeah? Presumption, if the agreement with family or friends, now family or friends, the agreement was not intended to be binding, commercial agreement, the other way around. So sometimes you want to sell to your brother to sister, you know. So this is more like family kind of thing. Yeah. So there's no much of commercial agreement need to be signed. So let's say I want to give myself my car to my brother, you know. So my brother is family friend. So don't need really to have an agreement kind of thing. So you give to your brother, and even the brother don't pay, doesn't matter because it's more we call it love and affection kind of thing. So the agreement is still valid lah. Is what they want trying to say. Consideration, exchange of promise to form act of future. So in any contract, remember, yeah, offer, acceptance, this is another third. You must understand in the contract to be valid, consideration. Accept just now, exceptional general, yes, have. Like say now I sell my car to my brother. He didn't pay anything. It's still valid because this exception. But normal contract must be offer, acceptance, and consideration. I sell, you buy, where's the money that you pay me? Say I sell the car to you, you say accept, but the consideration is let's say 10,000. He don't pay the 10,000, the contract is not valid yet. So just now you only learn two part: offer, acceptance, valid contract, plus have a consideration. But consideration can be many ways. That's why they didn't put it really first step, offer, acceptance, and consideration. No, they didn't put that. Therefore, offer, acceptance is a valid contract. Because consideration is a third condition. That means it can be condition in terms of money. It can be condition in terms of other ways. Let's say now I say that you go and repair my house for house leakages, so kind of thing. But for the repair, I give you free meal for 1 week. So that free meal is a consideration. Yeah. So that's why for valid contract first must have offer acceptance. Consideration is a third party. But for specific contract, you buy a car, then the consideration must be together lah. That's why if that situation, you have the three together. Buy and sell, where's the money? The money is the consideration. But consideration can be many ways. That's why the contract can be valid. Consideration is the third component. Little bit complicated, doesn't matter. You just try to understand. Any contract must have offer acceptance plus a third is consideration. But consideration can be in many ways. It can be in money, it can be in any other ways. Yeah. So that's what they say. And act of forbearance promise for anybody to constitute a price lah. Must be any price. A consideration must be a price lah. In another way, can be money, can be labor that you give them, all kind of things. Principle. Okay, we go a little bit. A valuable consideration is correct. That is the act of forbearance or promise must have some economic value. That means in this term, money lah. Yeah. Consideration need not to be adequate, but it must be sufficient. It not constitute a receipt price as long as there's some economic value. For example, I want to sell a house. The cost of the house is what you call it. Market price is 100,000, but I sell you at 80,000, still valid. Doesn't mean must be sufficient 100,000, but I want to agree to sell you 80,000 and you agree to buy, still valid. Not necessary you must buy at the market price of 100,000. That's what they're trying to say. Yeah. Consideration must move from the promise. So consideration, that means what you promise, the money must be transacted lah. You want to pay, the payment must be made. You promise to pay, that must be made. But if you promise to pay, the money never come into the account, so still there's no contract. The consideration must move from the promisee. You want to buy the house, you must pay the money to the friend. But your money is still in your account, contract is still not valid. That's why they want to say here, consideration must move. That means must be paid first. Consideration cannot be passed. Let's say, hey, last time I give you 10 ringgit, you never do me the work. Can you do it today? Cannot. Although yes, that one they give 10 ringgit, you have to pay him 10 ringgit lah. That is like say borrowing, but not contract. Contract must be current. Cannot use past consideration. Simple as that. Okay. Legal capacity. Okay. Who are legal capacity? Who can be party to a contract? Adults, but not if they unsound mind. Orang gila tak boleh. Yeah? Your mad fellow cannot, not legal, don't have the capacity to sign a contract. Contract is not valid. You sign with the mad fellow, the contract is not valid. Not valid means not enforceable in law. You cannot bring it to the court. Okay, that's what we said, not valid. Having the capacity to contract means the person entering into the contract has a legal competence. This means they are competent to perform and act agreeing to the contract. A person must have a sound mind and get its situation. So, just to hear, maybe it's not writing down here, but in law, the person must minimum age of 18 years old and with a sound mind. Sound mind with meaning. That means can a small boy do a contract? Legal capacity cannot, but he can sign a contract if the parent together sign the contract on behalf of it. Yeah. So in summary, acceptance is an act for implication that provide acceptance of an offer that form a binding contract. No acceptance, no binding contract. Simple as that. Intention to create legal relation indicates intention of parties to enter into a legal binding contract. Both parties must agree, have the intention. If the other party don't have an intention, so the contract cannot be bind. Okay. Consideration, I say again, in contract law, an inducement given to enter into contract that is sufficient to render the promise enforceable in court. I give you the example that house lah. Even you pay 80,000, house cost 100,000. So if both parties agree, intention is there, no problem, it's still valid contract. The technical requirement is either determined incurred by the person making the promise or the benefit received by the other person. So this is what for this today's topic lah. It's good enough for you already. You can understand and read more. The notes we give to you, you can Google more to understand more. Important that we teach, but whether you learn or not, do you learn? Whether you understand. If you understand, you learn. You don't understand, you have to ask in the class later on. You have to ask to the chat room, or you have to go to internet, read more the notes they give to you. You can even go to the YouTube channel and look into the subject. Is what? Now the subject is consideration. Acceptance. Our topic, which is acceptance? What is acceptance? So these are the things you want to prepare yourself to understand the topic on acceptance. So thank you very much. So hope you enjoy the lecture. It's a dry subject, but it's good subject for the purpose not only your exam, but for the purpose of you use it for your daily life. A lot of people gone into trouble because they don't know the law. Again, I repeat again, a lot of people gone to trouble because they don't know the law. So we are teaching you the law. Please learn it, not only for exam, but for your own use. So thank you very much.